Okay, Counsel, before we start, can you introduce us the speaking order and can you briefly introduce the case to us?
Yes, Mr. President. I'm Brandon Zhang. This is my co-counsel, Mark Maxwell Peter. I'll speak for 10 minutes.
Sorry. So before we start, I want to know like the speaking order. Can you and also like, is it possible for you to briefly introduce the case to us?
Yes, so the summary of the case is that the appellant, Mr. Antonio Fortuna, is a 32-year-old goalkeeper for the Iridonian national team. On 17 October 2025, Iridonia lost a critical World Cup qualifier 0-3 against bottom-ranked Cometland. A betting market analysis report from Genius Sports assigned the match a red rating, citing anomalous betting patterns and performance errors by the appellant, such as misjudging a pass that led to the first goal, Exhibit 1, and other suspicious actions that did not lead to a goal, Exhibit 1. And the Genius Sport reports can be relied upon for the betting analysis and performance analysis. And when the committee, the FIFA appeal committee required the appellant to submit his mobile phone, he refused. And the FIFA appeal committee imposed a 5-year sanction and a $100,000 Swiss franc fine on my client. So those are briefly the facts of the case. If there's no further questions, I will begin with my submissions.
Okay, thank you, Counsel. Can you introduce the speaking order to us? Oh, which I mean, like, how many minutes will the appellant speak? So is it like A1, A2, or like A1, R1? Yeah.
We represent the appellants, 10 minutes each for 20 minutes total, and then the respondents will speak for 20 minutes, split 10 minutes each, with 1 minute rebuttal and rebuttals.
Okay, understood. Okay, Counsel, may begin.
May I just ask who is the president?
Yeah. Okay, I will present.
Good afternoon, Mr. President and member of the panel. My name is Brandon Zhang. Together with my co-counsel, Mark Maxwell Peter, we represent the appellant, Mr. Antonio Fortuna. In the first 10 minutes, I will address issues 1 and 2, and in the remaining 10 minutes, my co-counsel will address issues 3 and 4. The appellant's case will demonstrate Mr. Antonio Fortuna was violated of his right to a fair trial when the respondent imposed a 5-year sanction on my client for match fixing. As a result, we appear today before the panel to ask that it reverse the FIFA's appeal decision. I now turn to the first submission. We submit that the statement of appeal is admissible for 3 reasons. First, the day of receipt is 2nd April 2026, therefore falls within the 21-day deadline. Second, the appeal was late due to an IT cyber attack. And third, Exhibit 8, the email, proves that the appeal was filed prior and on time to the deadline. According to Article 15, subsection 2 of the FIFA procedural rules, notification is deemed complete when the decision is communicated to a party. And under Article 15, subsection 4, states decisions that immediately impose sporting sanctions shall only be communicated with grounds. In our legal authority number 1, the 2016 CAS decision of Ivan Bellato.
Sorry, Counsel, what's your legal authority number 1?
It is the 2016 decision of Ivan Bellato Palacios versus PFC, CSKA Sofia. In that case, the panel held, accordingly, it was necessary for the player to get the motivated decision first. in order to file the appeal, and the panel at paragraph 75 held that the appeal was admissible as the grounds of the appeal decision was communicated to the player on 22nd January 2016, and the players lodged the appeal on 12th February 2016 on the very last day of the 21 days set by Article 67, subsection 1 of the FIFA statutes. If I may now direct the panel's attention to page 5, paragraph 26 of the record. Is the panel with me?
Sorry, 1 second.
Yeah.
Yeah, I have this.
Page 5, paragraph 26.
Okay.
Here it states that on 23rd, that on the challenge decision was sent to the parties with grounds on 2nd April 2026. This is Exhibit 7. And therefore, that is the day which triggers the 21-day deadline. In the next paragraph, at paragraph 27, on 23rd, 2026, the appellant paid a filing fee of 1,000 Swiss francs and filed the statement of appeal. On the very last day, 15 minutes prior to the deadline, at 23:45 Eridonian time. And therefore, we submit that the statement of appeal was filed on time prior to the deadline. Turning now to the second argument.
Also, when the time is not 31st March, but instead of 2 April, so the decision was fully upheld already, right? It's just not sent to the parties.
The decision was not a decision with grounds, and pursuant to Article 15, subsection 2 and 4 of the FIFA statutes, it requires where sanctions are imposed, they must be communicated with full grounds, which is deemed to be notified to the athlete under under Article 15, subsection 2 of the FIFA statutes. And in the case that I had just cited, this was precisely the case. The panel noted Articles 15, subsection 2 and 4, and held that the triggering day for the receipt was the decision with grounds at paragraph 74.
Okay.
If the panel has no further questions, I will turn to submission 2.
Yeah, please.
Please.
The respondent imposed sanctions when my client refused to provide his mobile phone. We submit that the refusal was lawful for 2 reasons. First, the privilege of self-incrimination is applicable because there are concurrent criminal proceedings. And second, my client has a fair...
Sorry, counsel. Criminal proceeding you mentioned?
Yes.
Okay.
Mr. President, there is currently ongoing criminal proceedings by the Eridonian authorities.
Okay.
I will take you to the paragraph in one moment. Secondly, my client has the right to a fair trial under Article 6, subsection 1 of the European Convention on Human Rights. According to CAS jurisprudence, Article 6, subsection 1 must be taken into consideration. I would like to introduce our legal authority number 3, the 2011, or legal authority number 2, the 2011 CAS decision of Amos Adamu versus FIFA at paragraph 66. I quote, "The panel is mindful that some guarantees afforded in relation to civil law proceedings by Article 6, subsection 1 of the ECHR are indirectly applicable even before an arbitral tribunal, all the more so in disciplinary matters, because the Swiss Confederation, as a contracting party to the ECHR, must ensure its judges, when checking awards, guarantee a fair proceeding within a reasonable time. These procedural principles form part of Swiss procedural public policy. And therefore, if now I may turn the panel with me to page 3, paragraph 13, please.
Okay, so I think
Is the panel with me? Thank you. Here, the Eridonian Public Prosecutor's Office launched an investigation into not only my client as well as my client's father. And therefore, where there is ongoing proceedings, there is a risk that the information will be shared by the sports organization to the public authorities. And in this case, it would be the Eridonian Police Investigation and its investigation authorities. And this was noted in our legal authority number 4 in 2007 cast decision of Jerome Valk versus FIFA at paragraph 266, where I quote, the panel stated, where there are concurrent disciplinary and criminal proceedings, the debate on self-incrimination appears debatable, and where there is a danger that sports organizations will misuse of information. In such a circumstance, there may be, in the view of the panel, a valid claim by the party or witness concerned to refrain from delivering self-incrimination information. And accordingly, we submit that my client had a right under Article 6, subsection 1, to refuse evidence to provide his mobile phone in which it would incriminate not only himself and his father potentially, since both appellant and father are both under criminal investigations.
sorry, counsel, why you will lead to self-incrimination?
Self-incrimination is an implied right under Article 6, subsection 1, which guarantees everyone the right to a fair trial. And here my client was not given the right to a fair trial simply because he refused to provide his phone. The respondent then imposed a sanction with only circumstantial evidence on the facts, which does not sufficiently prove, according to the mere comfortable standard of proof satisfaction, that my client has indeed violated offenses such as match fixing in the present case.
Did you seek guidance from your criminal lawyer or obtain a stay from FIFA pending that investigation?
Yes, Mr. Arbitrator. Accordingly,
You have your time is up, so I may give you a chance to answer this question.
yes, the appellant was specifically advised by his legal counsel not to provide his mobile phone, as this may violate his right to a fair trial and his right to privacy. And this is according to the facts and the FIFA's appeal decision.
All right, noted.
Unless I may be of further assistance, this brings me to
counsel. So if does FIFA have the right of investigation? Let's say like investigating to the phone. If FIFA do have the right, why you have the right to refuse such investigation, right? So far as I know this, it's not only in this case you're handling the phone, right? So let's say for doping cases that the athlete, for whatever reason, you'll be required to submit the certain samples to not only FIFA but also different kind of organizations. So why your client is so special that he can have such right to refuse?
Thank you, Mr. President. There is 2 reasons. First, as a contracting party to the ECHR, everyone is entitled to a fair trial. And this breaches Article 6 to a fair trial when the respondent does not allow my client to in the refusal and then to sanction. This violates Article 6, which subsection 2, which is also the presumption of innocence. And furthermore, there is concurrent criminal proceedings. For example, and this has been noted by the European Court of Human Rights case in the 1996 Funke versus France case, in the criminal proceedings, there was criminal convictions for refusal to produce documents, and the European Court of Appeal held that this was a violation under Article 6, subsection 1, where they violated his right against the privilege of self-incrimination.
Counsel, another question is like, even if you were to submit this, right, then if your client is refusing to submit such evidence to the court, and we found that maybe FIFA have no other way to obtain such evidence, and because your client declining to submit, right? So is it allow for this panel to draw an adverse inference that will be not beneficial to your client?
Yes, Mr. President. The respondent may in fact draw an inference, adverse inference. However, we submit that even when doing so on the facts, the evidence is not strong enough. And particularly in the cases of the respondent's arguments, in which they argue that the sporting genius report, the match betting report, that can only show that cannot pinpoint to one player, and if it only shows sport betting analysis of the whole game, it cannot pinpoint to exactly one player.
Okay, thank you.
Thank you.
Good afternoon, Mr. President. Am I audible?
Yeah, please.
Yeah, begin.
Yeah, please.
Yes, please.
Good afternoon, members of the panel. My name is Mark Maxwell Peter, and I represent the appellant, Mr. Antonio Fortuna. I will speak for 10 minutes, and I will reserve 1 minute for rebuttal. Issue C concerns two pieces of anonymous material: an anonymous witness statement and an anonymous email. And a simple question is, can these evidence ever take a comfortable satisfaction in match fixing cases? Our submission is that it cannot meet the standard. And even if this evidence is admitted, it deserves no weight. In the 2019 CAS case of Karamuddin and FIFA, the panel made it clear that anonymity is exceptional, not normal. It is only tolerated when the four safeguards exist, which are necessity, the verification of identity by the panel, the ability to test the evidence through protective cross-examination methods, and lastly, corroboration. Those safeguards exist to protect one thing, which is fairness, and none of them exist over here. Let us look at the witness. The witness says that they were afraid, not because of anything that happened, but because the rumors of the appellant's father. In Karamuddin, anonymity was justified because an objective third party confirmed a real risk, a co-witness who had been granted asylum. Here, we have nothing of that sort. No police assessment, no independent confirmation, just rumors. And unlike Karamuddin, there was no attempt at protective cross-examination, no audio scrambling, no visual shielding. The defense never allowed to test the evidence as seen on Exhibit 2, paragraph 5 and 6. What does the witness actually observe in this case? He sees Mr. Fortuna.
What is the main content of Exhibit 2? And just briefly tell me.
Right. Mr. President, the main content is, however, is stated on paragraph 5. Paragraph 5 is that, however, I had no choice but to request anonymity and my identity cannot be revealed ever. I'm afraid to face intimidation and threats for producing a witness statement in both FIFA and CAS proceedings. There are rumors that Mr. Luke Fortuna has friends involved in criminal organizations. I hear these organizations follow the under quotation snitches get stitches rule.
So, Counsel, it's just rumors, right?
Yes, yes, Mr. President. It's just rumors.
So, in CAS, if as far as I understand, the CAS jurisprudence allows for anonymous evidence in integrity cases.
Yes, Mr. Yes,
So,
yes, Mr.
what is your argument that it should be excluded entirely here?
Mr. Arbitrator, it should be excluded entirely over here because it does not meet the threshold of the preconditions which are stated in the CS case of Karamuddin. And as I would like to highlight the preconditions again, that it is not necessity. The verification of the identity must be done by the panel, and the ability to test the evidence. The reason why we want the witness statement to be put aside is because we do not know whether what the witness heard. For all we know, the witness could be making all these information up and trying his best to incriminate Mr. Fortuna for his own favors, such as having a better ranking position in the team itself. So it is imperative that we either test the witness and bring him in the court of arbitration to clarify what he saw, or if we cannot, then we remove his witness statement once and for all, because it is not admissible.
Okay.
Okay.
So let us look at the witness. The witness says that they're afraid not because of anything had happened, but because of the rumors of Parent's father. Unlike Karamuddin, there was no attempt at protective cross-examination and no visual shielding. Now, moving on to the observation, what does the witness actually observe? He sees Mr. Fortuna being stressed the night before the match, and he hears him say, "Dad, stop pressuring me," as seen on Exhibit 2, paragraph 8 to 9. But critically, the witness admits that he never hears what the father says. He only hears Mr. Fortuna's side. In the 2009 CS case of F.K. Poveda, it was held that the evidence is missing its context, and the evidence which cannot be meaningfully tested cannot be a standard of proof. Just because he was stressed does not mean that he manipulated the match. As an athlete myself, I have experienced stress before matches, and it's human nature to stress over things. And I've had conversations with my parents over the phone while they convince me to not stress over before the match, and I tell them, please, let me be at my own. So what I'm trying to put forward over here is that stress does not equate to manipulation. Now, moving on to the email.
Before you proceed,
Counsel, yes, Mr.
may I
Arbitrator.
ask you, the anonymous email referenced a crypto transaction which corroborated by the public prosecutor's investigation.
Yes, Mr. Arbitrator.
Does that provide any sufficient indicia of reliability?
No, Mr. Arbitrator. We would like to put forward the argument that the email itself was not traceable, the metadata was not verified, and the cryptocurrency and the crypto wallet itself, which the email signified, had no correlation or connection with Mr. Luke Fortuna. It was just provided by an anonymous witness. And it was said, and the screenshot of the WhatsApp messages also said that the payment has been transferred to the wallet. That is all we know. The rest, the public prosecutor has connected the dots itself. So it is safe to say that it does not provide a valid sort of evidence.
So you mean to say there is no sufficient connection between the cryptocurrency details which was provided in the email and...
Yes, Mr. Arbitrator.
Okay.
Now, moving on to issue D. We would like to assert that the Article 20 of the FIFA Disciplinary Code has not been violated. CS has repeatedly held in cases such as Orkyov and Pobeda that
What
match.
is the content of Article 20 of FDC?
Yes, Mr. President.
Just briefly introduce to me. No need to read
Yes,
the...
President. Mr. President, the Article 20 of the FIFA Disciplinary Code is the violation of match fixing. And we would like to assert that there has no, Mr. Fortuna and his father did not match fix or did not violate the Article 20 of the FIFA Disciplinary Code. First, I would like to walk you through the Genius report. FIFA heavily relies on the Genius Sports e-report, but Genius itself tells us what it's a report. It is an opinion. It flags suspicion, not investigation. It flags suspicions for investigation. It does not accuse individuals per se. On betting, there's no evidence that Mr. Fortuna placed bets, facilitated
For
bets.
such match fixing of the FIFA rules, right? What did the standard approve? So like it's a match fixing case, right? So I would like to know, like, if you are deciding on this issue, so what should be a standard approved?
Mere comfort of satisfaction, Mr. President. And here we do not meet the comfort of satisfaction.
Which case is it?
According to Article 39, subsection 3 of the FIFA Disciplinary Code, the standard of proof is to be applied in FIFA disciplinary proceedings. It is comfortable satisfaction of the competent judicial body.
So what level is it? Is it like criminal level?
It is, sorry, Mr. President, could you repeat that again?
So what standard approved is it? Is it like civil level or like criminal level?
It is of the criminal level, Mr. President.
Are you sure?
Apologize, Mr. President. It is less than the criminal level.
Okay, proceed.
Mr. President, as I see that I am running out of time, may I request for 1 more minute to wrap up my submission?
Okay.
Okay.
Thank you very much, Mr. President. On betting, there's no evidence that Mr. Fortuna placed any bets and facilitated bets. On performance, it reported highlighted errors, but errors alone have never been enough in the CS jurisprudence. Importantly, Iridonia dominated the early statistics. Possession was high, shots were higher. Decline came only after the second half, and it is consistent with the fatigue and physical condition, and not with the idea of manipulation. CS requires alternative explanations. CS requires alternative explanations to be excluded, and here they are not excluded. Lastly, moving on to the evidentiary bridge to Mr. Fortuna. The remaining evidence does not gap the bridge. The witness shows stress, the email were unverified, and the press release confirms only an investigation by the public prosecutors. There is no evidence Mr. Fortuna knew of any. There is no evidence of Mr. Fortuna knew of any payment made. No evidence where he received money. No evidence where he agreed to manipulate the match. And in the CS case of Povera, there was planning, threats, and instructions. Here, FIFA asked the panel to infer manipulation from suspicion alone. In conclusion, stress is not fixing, and Article 20, subsection 1 is not satisfied, and Article 20, subsection 3 is not engaged. The appellant therefore respectfully submits that Article 20 of the FIFA Disciplinary Code is now violated. If the panel do not have any further questions, I would like to end my submission.
Okay, just one question. Sorry.
Yes, Mr. President.
So you mentioned that errors alone does not equivalent to match fixing, but is it possible that your client had conducted so many errors that taking as a whole, it will be unreasonable to say it's not match fixing?
Yes, Mr. President. But at the same time, it could be said, it could also be said that because of the fatigue itself, which he was under, and the stress he was under for the first time performing in the FIFA level league, could also play a big part of that. He was also, according to paragraph 10, according to Exhibit 6, paragraph 10, he was also feeling a bit under the weather for a couple of days, and he discussed with the team doctor and told the manager that I would play regardless, even though he was feeling under the weather. So the probability of him performing but not performing at his highest level is very high.
Okay, Counsel, what my question is that is it possible that a lot of errors putting as a whole could constitute match fixing?
Mr. President, we would like to submit that no, it will not be constituted as match fixing.
Okay, so is there any authority to support that?
I would like to refer to my written submissions, Mr. President, but as of now, we do not have authorities for statement.
No problem. Okay,
Thank you. Thank you very much.
thank you. Yeah. Brandon. Is it possible for you to give us the case brief?
Copy.
Yeah. Also, we don't have the story also.
Physically rule, is it?
Yeah.
Okay, then it's again, physically right. We don't have our legal items.
Maybe just give us.
We don't have our bundle, but this is my subs, and then we want the fact.
That's just a
right
case.
here.
Yeah.
Yeah, so this front section is just the facts, and then all the exhibits are.
The exhibits are there.
Oh, really simple.
So you can just look at the exhibits and then just
Okay.
So like if they say like page 5, it'll just be in the first right here. These are old submissions. So actually,
Okay.
you can, this is old submission, and this is the.
Thank you, Master.
Before I begin, could I confirm that the panel can hear me loudly and audibly?
Yes, no problem.
Yes, please.
Thank you. Before I begin, I also understand that the panel would like to understand the speaking order and to firstly address that my name is Seah, and I'll be addressing the first 2 issues on appeal, namely whether the statement of appeal is admissible, and secondly, whether it was lawful for the appellant to refuse to hand over his handphone, and I'll be speaking for 10 minutes. And my co-counsel, Mr. Ramesh Kanna, will be addressing the remaining 2 issues on appeal for 10 minutes, and we reserve 1 minute for a rebuttal.
All right.
Thank you. I'll now begin my submissions. Members of the panel, fairness governs these proceedings, but fairness here means applying rules consistently. The panel is not asked to weigh certainty against justice, but simply to decide whether an appeal filed outside mandatory time limits can proceed, to which the answer is no. Further, the appellant's claim of self-incrimination does not override the need to protect the integrity of sport. He was lawfully and proportionately required to cooperate in a serious integrity investigation, as noted by Mr. President earlier. Such refusal is unjustifiable where cooperation is essential to the investigative process, and therefore, the respondent submits that the appeal is admissible and the appellant had breached his duty to cooperate. Turning to the first issue, we submit that a statement of appeal filed by Mr. Fortuna is inadmissible for 2 reasons. Firstly, the decision on 31st March already forms an appealable decision, making a deadline 21st April. And secondly, the appellant had missed the deadline to file the appeal brief. Turning to the first argument, following the 2015 case decision of GFF and FIFA, a mere letter qualifies as an appealable decision if it affects the legal situation of the addressee, i.e., as long as it contains a plain ruling. And if I could then turn the panel's attention to Exhibit 7 of the record, which could be found at
Okay.
the last page of Exhibit 7, which shows the challenge decision.
Okay, we're now.
If the panel is with me.
Yeah, so page 1 of the Exhibit 7, is it?
Oh, no, the last page of Exhibit 7.
Okay. Last page. Okay.
Where it shows the plain decision, counsel.
Okay.
This plain decision without grounds was held on 31st March, as noted in para 26 of the record. Therefore, this decision contains a ruling which affects the legal situation of the addressee, making it an appealable decision. And secondly, we note that counsel for the appellant has submitted that the decision must contain the full grounds for it to be considered an appealable decision, to which we say we do understand that that is a possible case decision, and we do understand that case is not bound by stare decisis. However, even if we take the appellant's submission that the statement of appeal did not expire, this appeal brief was filed out of time without reason. Pursuant to Article R51 of the CAS Code, the appeal brief must be filed within 10 days of the expiry of the deadline of the statement of appeal. And on that basis, if we do accept that the deadline is 23rd April, as argued by counsel for the appellant, The 10-day period expired on Sunday, 3rd May, as 10 days from 23rd April is 3rd May 2026.
Sorry,
And
Counsel. Sorry, I think the appellant say that they are following the FIFA disciplinary committee rule for 21 days, right? So which one should prioritize, the CAS code or the FIFA code?
With regards to the appeal brief, Mr. President, the FIFA code does not expressly provide for such provisions, and therefore, in times when it is unclear whether FIFA's statute is whether FIFA statute is clear on such procedural issues, we can rely on the CAS code for clarification. And clarification in the sense of when the appeal brief can be relied on. And by operation of Article R32 of the CAS code, the applicable deadline therefore was extended to Monday, 4th May 2026, as Sunday is a weekend. However, as noted at paragraph 33 of the record, the appeal brief was not filed until 5th May. 24 hours the applicable deadline has elapsed.
So which paragraph?
At paragraph 33 of the record.
33.
33.
Okay. Understood. Okay.
And the consequence of such a late filing is well established in CAS decisions. As noted in 2019 CAS decision of Club Sportif and Jose Paulo Sousa, the panel held that a failure to file an appeal brief within the prescribed time limits rendered the appeal inadmissible. While the appellant may elect for the statement of appeal to serve as an appeal brief, no such election was made in that case. And on the contrary, in our case, by filing a separate appeal brief out of time, the appellant is implicitly submitting that no such election would be exercised. And in these circumstances, we submit that the appeal is inadmissible for failure to comply with the mandatory time limits set out under Article 51 of the CAS Code regarding the appeal brief. And unless you have further assistance on the first issue.
Yes, Counsel. So I have one question. So basically, if I'm not wrong, you're saying that the appellant only filed the appeal brief on 5th May. So when it filed the appeal, it could be counted as 5th May. However, I also noted that they filed a filing fee on 23rd of April. So you mean that it must be an appeal brief to be appealed, is it?
Appeal brief is considered a supplementary document that is required for the appeal, and this is noted inside the CAS code under R51. And to answer Mr. President's assertion earlier, the filing fee was for the statement of appeal, not the appeal brief.
Yeah, but in that case, on 23rd of April, the appellant has shown a very clear intention to appeal. So shouldn't the panel consider that as they have such intention, so we should keep the proceeding continue?
I do understand that a panel would assert that there is an intention for the appellant to file an appeal, but we have to concern ourselves with the procedural guidelines that govern today's proceedings. A statement of appeal must come together with an appeal brief, and the only situation when an appeal brief is not required is if the appellant themselves explicitly state that a statement of appeal is considered to be the appeal brief, because the appeal brief sets out the grounds of their appeal. And without the appeal brief, this renders the panel to be unable to understand exactly what the appellant today is appealing about. And therefore, we submit that it's an essential document to today's proceedings.
Okay.
And I'll now turn to the second issue. The appellant's refusal in handing over his mobile phone is unlawful for two reasons. Firstly, the appellant had breached the non-negotiable duty to collaborate under Article 12, subsection 5 of the FIFA Disciplinary Code. And secondly, Article 6 of the ECHR is inapplicable to our proceedings, rendering his defense of self-incrimination null. Turning to our first argument, according to Article 12 of the FDC, persons subject to this code shall help to establish and or clarify the facts in a case or any possible breaches of this code, and in particular, shall provide any evidence as requested. And in the present case, if I may direct the panel to page 4, paragraph 20 of the record.
Which paragraph? Sorry.
20.
Paragraph 20 of the record.
Thank you.
Mr. Fortuna immediately refused to cooperate when FIFA representatives requested that the appellant submit his mobile phone for the purposes of their investigation. This refusal was sustained despite multiple requests, which therefore shows a clear violation of Article 12 of the FDC. And on this note, we do understand that the appellant is invoking the privilege against self-incrimination under Article 6 of the ECHR. However, CARE's jurisprudence is very clear that Article 6 of the ECHR, which provides criminal guarantees, are inapplicable to today's proceedings because FIFA proceedings are fundamentally civil or ethical proceedings, not criminal proceedings. And this was noted in the appellant's own case that he cited in the 2017 CARE's decision of Jerome Velke and FIFA, which noted that guarantees recognized in a criminal trial are inapplicable per se in a disciplinary proceeding before FIFA, as FIFA is a private entity and a sanction imposed on an appellant is purely based on private law. This is further supported. Yes, Mr. President.
So you mentioned, so in the case you both sides cited, is it a case of match fixing?
No, Mr. President.
Okay, so
Yeah.
okay, so counsel, here's the thing. I noticed that in a very old case, in 1998 case, the case mentioned that for case like doping and match fixing, it's a quasi-criminal case. So if the case is actually quasi-criminal, why couldn't we use some certain rule like ECHR, which is quite in a criminal content, to protect the right of the respondent? Protect the right of the accused. Yeah, sorry.
I understand, Mr. President, and I understand that the quasi-criminal element can come from the fact that the Iridiana public prosecutors are holding a concurrent criminal investigation into our case. However, Jerome Velke notes that in case where there's a concurrent criminal proceeding, the protection against self-incrimination can only be invoked when there is a real and clear, there's a clear and imminent danger that a privilege against self-incrimination will be circumvented. And the only case where they recognize is where there's a collaboration between the sporting organization and public authorities to which both parties would share information, which may prejudice Mr. Fortuna's protection against self-incrimination. Members of the panel, I do note that my time has elapsed. If I may have a short 30 seconds to finish my answer to Mr. President.
Yeah, please.
Thank you, Mr. President. The most crucial fact against the appellant's claim of imminent danger is that the Iridonia's public prosecutor office explicitly refused to share evidence with FIFA. And if I could turn the panel to page 4, paragraph 15 and 16 of the record.
Yep, please go ahead.
The prosecutor stated that they will only share information after their investigation was concluded and the case was ready for court. And this refusal demonstrates that the state authorities are protecting the integrity of their own criminal cases and there's no active collaboration between both parties, negating the claim that there's a clear and imminent danger that PSI will be violated. And unless I may be of further assistance on the second issue.
No, I'm good.
Thank you, members of the panel. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining 2 issues on appeal. Thank you.
Thank you.
Before I begin, could I check if I'm audible to the
Yes,
members?
yes, you are.
Good evening, members of the panel. My name is Ramesh Kanna and I act for the respondent, FIFA. Now, today I have 2 submissions before the panel. Firstly, the anonymous witness statement and the anonymous email are admissible. And secondly, Article 20 of the FIFA Disciplinary Code has indeed been breached by the appellant. Now, firstly, with regard to the first submission, I note that opposing counsel has made various distinguishing elements from the case of Karamuddin. While it may or may not be analogous, the panel should not be worried about this and instead should focus on the underlying principle behind why Karamuddin adopted these measures. And that goes to Article 6 of the ECHR. Now, Article 6 of the ECHR is relevant because this tribunal is seated in Switzerland. And as a result, the procedural validity of these proceedings is governed by Swiss law.
Your co-counsel just mentioned that articles, for your submission, articles that ECHR is inadmissible, right?
For the issue that he was arguing on, Mr. President.
But now for your issue, it's admissible.
It is. And the reason for that is because the underlying principle behind why generally anonymous evidence should not be admitted lies on 2 principles. 1, the right to be heard, and 2, equal treatment. And these 2 are governed by Articles 182 subsection 3 and 190 subsection 2 of the Swiss Private International Law Act. And these have to be considered in the context of Article 6. And this has been repeatedly
Counsel, if
stated.
I may interrupt. So you mean to say you can cherry pick when you can apply Article 6 for the prior issue and this issue? Is that what you are arguing?
To clarify, Mr. Arbitrator, we are not stating that Article 6 can be merely cherry-picked. Rather, this argument that I assert is based on CAS jurisprudence. Because even the case of Karamuddin that the opposing counsel relies upon, many other CAS decisions such as Pobeda and Orikov have relied on Article 6 in order to develop on how the right to equal treatment and right to be heard should
Yeah,
be.
we totally understand that what is your argument about, but we are more concerned with the flow of the argument, wherein on one instance, Article 6 was contested that it won't apply. However, on the next issue, the counsels are arguing that you can rely on Article 6. So that is where the discrepancy is, and we are concerned with that approach.
I understand the concern the tribunal has, Mr. Arbitrator. However, I would like to reiterate that the issues are of a different nature. And the first issue was my co-counsel was arguing on the right to self-incrimination, and I am arguing on the general barring of anonymity. And this is indeed the divergent approach that the CAS jurisprudence has taken. So if we were to look at the precedent, this would be the favorable approach for the panel to assume.
Okay, proceed further.
Now, as per the ECTHR Article 6 guide, there are 3 elements that are required for reliance on anonymous evidence. Firstly, there must be good reason for non-attendance. Secondly, the evidence must not be sole or decisive in determining guilt. And thirdly, there must be counterbalancing factors that safeguard fair assessment of reliability. Now, I do note that the opposing counsel had done a piecemeal distinguishment where he had stated that in the case of Karamuddin, there were audio-visual scramblers that allowed for meaningful cross-examination, and in the current case, this is not possible. However, audio-visual scrambling is not the requirement that is necessitated. Instead, there just has to be counterbalancing factors to ensure that the piece of evidence is not solely or decisively relied upon and can be tested for its reliability. And one such measure is corroboration, which the opposing counsel himself cited. And in this case, there is indeed corroboration with this anonymous witness statement and the anonymous email. If I could...
Can you please highlight what is the corroboration about more specifically?
Yes, Mr. Arbitrator. So, firstly, beyond the anonymous witness statement and the anonymous email, there's also been an objective report that has highlighted performance inadequacies on the part of the player. And it is to be noted that these performance inadequacies occur at a time that coincides when the market has taken anomalous betting swings. Now, this sort of objective evidence has been seen by the CAS panels in previous precedent cases such as Orikov and Pobeda, where objective third-party evidence such as these reports can corroborate anonymous pieces of evidence. Now, in this case, I do note that the tribunal might find issue with the fact that the opposing counsel had raised earlier, which is that the player had initially complained of being under the weather and of being in fatigue. But it's to be noted that within the first 20 minutes of the game, the Iridonian team had 68% of possession and was also seen to be winning. Now, the opposing counsel's theory falls apart when we consider that fatigue, something that the appellant hypothetically should have been dealing with throughout the game. It is too much of a coincidence that the appellant chooses to make these performing errors right at the moment of the 20th minute when the market takes an anomalous swing and anomalous betting patterns are realized. Thus, we argue that this anonymous witness statement indeed is corroborated. And I also note opposing counsel's previous argument regarding the fact that there is no context
A quick
for the
question.
witness.
Sorry to interrupt you. So, okay, it is corroborated because of the market anomaly. But is there any other corroboration? Because this may not be sufficient to implicate the accused only just with one collaboration. Do you have any other facts or evidences which can corroborate it any further?
Understand, Mr. Arbitrator. I'll answer your question in two parts. Firstly, the market anomalies should be considered as two separate pieces of evidence because one is a report that highlights performance anomalies, and the second is a report that highlights betting patterns that are anomalous. Now, to move on, in addition to these two pieces of evidence, there's also an anonymous email that has shown that Mr. Luke Fortuna, that is the appellant's father, has had alleged connections with a syndicate, and there has been a transfer of significant sum of cryptocurrency. Now, this also adds to the inference that the father had indeed intimidated or persuaded the appellant to make performance errors so that the syndicate can pay him a significant sum in return to ensure the outcome of the match.
Is there anything to link father and the son, that the son was aware of what that the father received Dogecoin or the cryptocurrencies?
I understand the question, Mr. Arbitrator. This will go into my second submissions with regard to whether there's been a breach of Article 20, which I would gladly move on to if members of the tribunal have no further issues regarding my first submission.
You can address it here, and maybe in the next issue you can avoid that part.
Now, with regard to whether the appellant must have had a link with regard to the monetary transfers, cases such as Orikov and the FDC Article 20 itself states that participation need not be direct, and indirect participation, that is, benefits accrued to third parties through the performance of the alleged accused, is sufficient to meet the threshold of Article 20 of the FDC. So now, even if the appellant does not directly have a hand in the cryptocurrency transfers, the fact that the father had intimidated or persuaded the appellant to do so, and the appellant had indeed acted in accordance, is enough to satisfy the comfortable satisfaction threshold under Article 20 of the FDC. And to answer Mr. President's earlier question to opposing counsel, the standard of comfortable satisfaction is one that is greater than a balance of probabilities, but less than beyond reasonable doubt. That is the criminal standard.
Noted.
Now, moving on to my second issue. There has to be 4 elements that are required in order to prove that Article 20 of the FTC has been breached. Firstly, an act or omission of either player must have taken place, and this omission must have had a part in ensuring the outcome of the match. And thirdly, there must have been either indirect or direct participation, and there must have been an attempt at a conspiracy at least. Now, I note that my time has elapsed, members of the tribunal. If I could request for 1 more minute to sum up my submissions on the issue. The 2 elements that are in dispute for this issue are just whether there was indirect and direct involvement and whether there was an attempt to conspire. Now, the case of Pobeda is instructive in that it is not any one piece of evidence that the panel must rely upon, but rather the mosaic of evidence that is built on by every brick of evidence that should be looked at in totality when considering if a particular alternative that is reasonable is convincing enough for the panel to not be comfortably satisfied with an inference of guilt. Now, I do understand.
What is the authority for that? I noticed that all your evidence here is all circumstantial evidence, right? So is it allowed for us to use circumstantial evidence only to prove the case?
Apologies, Mr. President. Could I request for you to paraphrase the question?
Okay, so is it allowed for this panel to use only circumstantial evidence to prove the case?
Yes, Mr. Arbitrator, because in the case of Orikov, it's an analogous situation where betting anomalies, performance analysis, and witness statements were relied upon for an inference of guilt. Thus, indeed, this panel is empowered to make such a decision.
Okay, so in that case, is it since the evidence you have is only circumstantial evidence, and what your allegation is match fixing, right? So it's a very serious allegation. Shouldn't we take the such standard of proof to a very high level?
The standard of proof as far as CAS jurisprudence goes does not change with the nature of evidence that is relied upon, Mr. President. The standard of proof remains to be one of comfortable satisfaction. However, your concern can be addressed in the weighing of evidence. For example, in cases such as Pobeda, where the witness statement was not properly corroborated and lacked context, the panel just accrued less weight in determining guilt. Now, I also note that my time has once again elapsed. If I could just answer any further questions you have and summarize my position in a short one-liner.
Please.
There are no questions, Mr. President.
Yeah, no more question.
What we rely on is that it is not a singular piece of witness statement or the performance analysis, but rather the fact that all these pieces of evidence corroborate together to form this mosaic that leads to no other possible alternative explanation other than the fact that the player had indeed performed poorly in order to manipulate the match to achieve a particular outcome. If there are no further questions, I rest my submissions.
All right, I'm okay. Okay, thank you.
Thank you. You got rebuttal, right?
Yeah, just double checking on.
Okay, sure.
Let's see what we got. Thanks, bro.
Mr. President, am I audible?
Yes,
May I begin?
Yeah,
yep,
please.
yes, please.
Thank you. So, my opposing counsel raised the question of genius report, and we would like to state that suspicion does not mean attribution. FIFA relies heavily on genius report itself, but genius report tells us what is and what is not. It is an opinion which flags suspicion, but it does not cause or accuse individuals. It is important to note that the Iridonian team dominated the early statistics of the match. Possession was high and shots were higher. But the decline came after the consistent fatigue and the physical condition, not by manipulative design. It is simply what we are trying to say, that over the time, Mr. Fortuna lost control over his health and he fatigued going forward. As mentioned in Exhibit 6, paragraph 10, I would like to quote that he was feeling under the weather for a couple of days, and he was told and he informed this information to the team doctor, but he continued to fight, he continued to compete in the match anyway because he wanted to represent his company at his full and at his best. So it is safe to say that his condition was not made his condition was not purposely for manipulation, but rather he just went through a physical condition which was fatigue and he lost control over his health. Thank you. That would be my submission.
Thank you.
Still you want a company or? Members of the panel, if I may begin.
Yes, please.
Opposing counsel had stated that suspicion does not equate to a finding of guilt. Well, we in fact agree. We're not asking the panel to make a conclusive decision on guilt based solely on the Genius report. Rather, the focus here is the fact that the performance of the appellant considerably degraded right at the 20th minute mark when the market made an anomalous swing. Now, this leads to the second point of the opposing counsel's rebuttal, which is he states that the physical fatigue and the health impacts faced by the appellant were the reason for this poor performance, but it fails to address the coincidence of the player's poor performance with the market swing. This remains to be addressed, and there is no reasonable explanation provided for this particular anomaly by the opposing counsel. Thus, I conclude my rebuttals.
Okay, thank you. Yeah, stop recording.